result in the abuse of these laws, and abuse from the perspective of suppression of public discourse, terms of violation of human rights. So I just want to start my presentation just to present a few the, um, headlines which shows from around the world, what type of abuse has occurred. And these are headlines from the last 12 to 18 months. As you can see, there have been issues with abuse of cybercrime laws in Jordan, in Thailand, Pakistan, Egypt, Philippines, India, Senegal, in a number of different locations, and it ranges from targeting and victimization of opponents of public officials. It ranges from digital rights abuses in terms of internet shutdown to prevent persons from expressing themselves or expressing a discord or disagreement with the government. It ranges from attacks on individuals in terms of spyware, disproportionate mass surveillance of individuals. So I just wanted to use this as a bit of the backdrop for my discussion. I had submitted a number of different comments. I discussed illegal access. My perspective in terms of illegal access is there are a number of legitimate uses of so-called access in terms of testers, researchers, activists, whistleblowers, which actually serve the public on good. So I just want to be sure that you can understand that specific impact. Particularly, a big concern is that we have a lack of trained court officials, and we don't have a specialized court. Speaking of this in terms of specialized courts, for example, the UK has the King's Bench Division on Technology, which has specialist judges, which are known as masters, who have special and training to address and adjudicate these type of matters to make sure that innocent or well-meaning persons are not imprisoned. This particular section on modification of programs or the data, this is particularly important because it's misaligned. It's not present in the Budapest Convention, the Commonwealth Model Law on Cybercrime, the Malabo Convention, or any other of the cybercrime model laws. This is actually an outdated term, and it also uses outdated language, and it criminalizes a number of modern productive use cases for modification of software and data processing, whether it be artificial intelligence, free and open source software, open data policies, and creative commons in terms of modifying and sharing data, permission granted to modify and share data outside of the normal authority of the person who has created that program or data. This section particularly is an unnecessary session, and my recommendation is that it should be removed. It can be addressed by Part 2.6, which should be actually changed to interfering with data to better align it with the Budapest Convention. Interfering with program or data, that's Part 2, Section 6. This again uses outdated language, and it should really focus on somebody that has intentionally, without authority, and causes the harm. If something is temporary or not, and doesn't cause harm, it shouldn't particularly be a crime. Criminalizing minor acts, especially acts that don't have any harm in terms of public good, individual harm, corporate harm, is unnecessarily criminalizing individuals. Same thing with part 2.7, interfering with a computer system. This is another particularly concerning section in terms of poor legislative drafting. And it really doesn't address the true criminality, which is really, again, focused on intention without authority and seriously hindering the functioning of a computer. And many of the laws, including the convention, focus on seriously hindering serious harm to ensure that minor infractions are not criminalized. Illegal interception of the data, which is part 2.8. I wanted to focus on this section because interception of public information, and this is why I particularly to talk about the lack of understanding of modern computer systems and data management, because usually one of the foundation of the data management is classification. So if data is classified as public, sensitive, confidential, strictly confidential, if data is public, why should someone be charged for interception of the data that is publicly available? I think that's a misnomer, and you should really look at if the intention is dishonest, if the intention is harmful, and if it's the intersection of non-public information. The misuse of the devices, I've mentioned this in my submission. I want to particularly refer to the Budapest Convention, which says that misuse of devices, illegal access, interfering with a system, all of these should not be interpreted as imposing criminality, and not for the purpose of committing an offense where it is authorized testing or protection of a computer system. So where there's legitimate use to protect a computer system, to ensure a computer system is robust and resilient, these type of laws should not be used to criminalize those practices. The critical information infrastructure section, which is part 2.12. My concern with this section is that really and truly this is unnecessary for a cyber crime bill. It's already being addressed in multiple different sections of the bill. What you really need to do is to create a separate critical infrastructure protection legislation that focuses on obliging critical infrastructure providers to implement strong cybersecurity measures and making sure that you're monitoring and ensuring that those measures are in place. That goes a lot further than in terms of protecting our critical national infrastructure than a kind of symbolic section about critical infrastructure.
Mr. Harper, just wish to inform you, you have 2 more minutes.
Yes, I know that.
2 more minutes.
And I just want to stop a bit as well, just to reinforce. We've had a number of people submit for 2 hours, 5 hours of public submission, and an actual expert, you're restricting their submission to 10 minutes. I think that's a bit unfair. With that being said, malicious communications, again, this really focuses on criminalizing to a large extent, which is just normal discourse, online discourse. Another key thing is the Budapest Convention and other model laws do not address malicious communication. Also, trying to treat the cyber crime bill with criminal defamation is very, very problematic because the European Court of Human Rights, the United Nations, several human rights organizations, as well as intergovernmental bodies maintain that criminal defamation laws are an unjustifiable affront to human rights. Several progressive nations have actually removed criminal defamation laws from their books. The section on cyber bullying as well. Adults are supposed to be resistant to hurtful words. If you look across progressive nations, cyber bullying laws focus on schools, children and adolescents. They don't focus on adults, and when they do, they're particularly restricted to violence acts, sexual abuse, and harassment. Search and seizure, I've already mentioned all of these other things in my submission. I just want to go to the last part. We have a problem in Barbados with capacity and building. We don't have a national strategic cybercrime capacity building approach for training the law enforcement, prosecutors, magistrates, and judges in terms of making sure that they have continuous development, that they understand existing and emerging technology, how those technologies interact with the law, and to ensure that they have the right knowledge and skill set that they can actually administer these types of cases when they do come in front of them. So that being said, I will stop. I'm here and I'll take any questions.
Thank you, Mr. Harper. Any committee members wish to raise any issues which Mr. Harper has presented in either his written or oral submissions? Okay, let me ask then. Mr. Harper, in your written submission, you criticized, well, Section 9A and 9B. Let me just get them under misuse of devices. And you can correct me if I am misunderstanding you, but the section speaks to for the purpose of committing an offense. All right? Person who intentionally or recklessly and without authority for the purpose of committing an offense. That's Section 9A1, for instance. Section 9A2, same thing, for the purpose of committing an offense. So wouldn't you agree with me if I were to argue that hence the use of this device for legitimate testing and protection of computer systems would not come within the prohibitive ambit of Section 9? Because obviously if you're using it for legitimate purposes, as you have argued, comes within the criminality of that section, you would not be using it for the purpose of committing an offense.
So just to be unclear, offense here is a very nebulous term. It's not properly defined in the bill. In many places, what are offenses, again, are normal interactions with human beings online. There are other legitimate uses in terms of accessing programs, remixing software data, addressing or using computer systems without the permission or the authority of the person who created them or the person who is licensed the software. So what exactly is an offense? Because you've defined a number of offenses that in the real world are not actually offenses. So my position was that if you don't properly define a offense, or if you don't train your magistrates and your judges to understand what these actual offenses are, then you run the risk of criminalizing what is not an offense, and finding or imprisoning someone unjustly.
But Mr. Harper, I will want to argue with you that we have separation of powers in Barbados, as you know very well, separation of the judiciary from the legislative body. And Parliament cannot go into detail and define every single word in every single act. There has to be a role for the judiciary. And that's the judiciary's prerogative to say whether it's an offense or not. That's my argument, sir. And I mean, I'm speaking as a lawyer for 40 years too. There has to be a role for the judiciary in this. What I would agree with you, sir, is that the judiciary, therefore, we need to ensure the judiciary is well trained in it. As for example, as I understand it, in September, when there was a 3-day seminar here, which Sir David would have mentioned in his submissions, oral submissions, the last time we met, judiciary was invited as well. So I think your stronger argument is that, yes, we have to ensure that the judiciary is well trained on this issue, but to say, sir, that Parliament should usurp the role of the judiciary and tell the judiciary exactly what is the definition of an offense is, etc., leaves, in my opinion, infringes and usurps on the independence of the judiciary, which is a fundamental concept of our system of governance and our laws.
So my response to that is, first thing, a 3-day workshop, which I'm very familiar with those workshops that are done by the Council of Europe. That's not training. That's not education. It's this course on best practices and protecting human rights, etc. That's not training. I've trained for cyber crime law, cyber security, privacy, and other similar matters for the last 20 years. And we ensure in our field that there's continuous education, 20 hours, 40 hours, 60 hours, 80 hours per year, continuous education to ensure that as technology shifts and you see emerging technology, new technologies which affect crime in different ways, that you stay in touch and you better understand so you can administer these laws again. So yes, you're right, they should be trained, but I also want to say this. I'm not saying that the separation of powers should be usurped, but if you look at, again, progressive nations, they have explanatory notes explaining in detail what are our crimes, how to understand the difference between the acceptable use and criminal use. They have the guidelines, they have white papers. These are administered along with the laws to serve as guidelines so magistrates and judges can better understand these subjects and make sure that they're administering the laws in the right way.
Thank you, Mr. Harper. So at least you seem to have conceded that in terms of the legislative provision, there's nothing wrong, but obviously in terms of the administration now of the law, that Well, the government, and that's different from the legislature now, has to try and ensure that there's proper training in terms of the administration of the law. Your
Um,
power.
so, so just to be clear, my submission very clearly says that there should be training. So should be some type of note or training that make sure that your magistrates and your judges understand the law. So there's nothing to concede because I think we're on the same page.
In terms of your criticism and comments on Section 12, the categories of critical information infrastructure system, and I'm reading your written submission to say that this should be dealt with in regulations as opposed to in a parent act. Well, that's a matter, I think, for the legislative drafters maybe to advise on, but the categories of critical information infrastructure systems should not and cannot be closed. And I think we all accept that in terms of evolving society and governance, just like how categories of negligence, a judge once said, in case law can never be closed, categories of critical information infrastructure system cannot be closed. And therefore it would be contemplated that subsequently that this category would be widened. So what is your comment on that?
To address that, so I was very particular with my recommendation. So if you look at the United States, the European Union, if you look at India, Bangladesh, other countries, Sri Lanka, and I'm very familiar with those countries because I have developed their capacity building. I've trained their judges, their legislators, etc. They have what are called critical infrastructure legislation. What that legislation outlines in detail what is critical infrastructure. It outlines what you need to have in place as a critical infrastructure provider in terms of cybersecurity requirements, computer security incident response. It puts obligations by law on critical infrastructure providers that they protect their critical infrastructure of the nation. And they also create a government department that their job is oversight of critical infrastructure providers to ensure that those strong cyber security measures are in place. And what I'm saying is that goes further in protecting national infrastructure than criminalizing access and unauthorized access to critical infrastructure, because the majority of the persons who are going to access your critical infrastructure and do you damage are not in Barbados. There are people in Eastern Europe, in North Korea, and these are people that are will obscure their locations and their identity online. So you can't even bring those persons to justice. So what I'm saying, instead of focusing on a symbolic and a useless clause, you should focus on implementing laws that actually protect your critical infrastructure.
And my final query to you, Mr. Harper, relates to paragraph 11. Paragraph 11, section 11, disclosure of access code, where you've been critical of this section, and it is arguable, it is certainly arguable, I want to concede that section, subset 1 and subset 2 of section 11 is that they are duplicitous, and that one could perhaps be eliminated, as you seem to be saying. Which one you would eliminate if given the choice?
So it's not even a which one. I think that whole section is not a useful section. That's not present in, if you look at any model law or treaty. that's not that's not addressed, because there's so many normal use cases and non criminal use cases for disclosure of access codes. You use shared codes when administering systems. You use shared codes when you're doing the encryption. You use a number of different shared codes, and sometimes it may not. It may be without formal authority. It may be interpreted as reckless. At the end of the day, this is not treated as a cyber crime in Malibu Convention, the Commonwealth Model Law on Cybercrime, as well as the Budapest Convention. This is just not addressed. I don't see a reason for this section.
Mr. Harper, Ramel Spring here, and I read your written submission, and I must admit that when I first read that bit in the legislation, it did flag up some concerns for me, and I think I raised it here during our initial discussion. At least I intended to. You're saying that basically that, and I caught that when I came in and I heard your oral submission, that we're basically criminalizing trivial matters, and this would almost, and that's me paraphrasing your words from what I understood you to be saying, and this in a sense is a trivial matter, and that there are many normal usage where persons may inadvertently disclose access codes, passwords, and so on and so forth. But the legislation speaks to A, the reckless disclosure, and B, it also speaks to, I guess, disclosure or gaining access to these codes, passwords, and so on for unlawful gain. They're using that to I guess, to earn or to gain money unlawfully. I'm assuming that there's in most cases, that's the reason why people engage in things. And working in a ministry where data is so critical, data is so important, I can't see a scenario where there's not a piece of legislation that looks specifically at situations where persons, because of the clearance that they have in their jobs, in the areas that they work, may not necessarily be listed as critical. I mean, I don't know if the CIA Licensing Authority, for example, is listed or seen as part of the critical infrastructure. It may very well be, but there's a lot of important data that is stored, or persons who work within that department has access to, that can be sold on the market. And I believe that persons, if given that level of clearance and engage in any kind of unlawful, reckless disclosure of that information, whether it be names, codes, passwords, what have you, there should be something in the law that gives the authorities some sort of recourse. And if you were to remove this section altogether, then I think, I mean, of course, there are other ways that persons could be prosecuted, but I think that this here gives us more direct authority in terms of how we would treat the persons who engage in that type of behavior, that type of criminal activity. So if you can speak to using those types of scenarios that I just placed there on the table. Of course, there are other situations where I don't believe that a person who, because they work for me and have access to my password, to my computer, or anything like that, that if they share that password or tell somebody that password, I obviously would want to see that person being fined $25,000 or 3 years in prison. But I would want that there's some sort of legislation to protect me from even the person thinking about that they can share my information on IG.
Okay, so this
social media platform.
So just to be clear, you have quite a number of sections that address that. You have illegal access. You have misuse of devices. You have interfering with a computer system. you have interfering with data. Like, I mean, part of my concern, again, there are a number of redundant sections in this bill that serve no purpose except as to confuse magistrates or judges, especially the untrained ones. Again, I want to circle back to this is not treated in any other law. This is actually a holdover from our Computer Misuse Act. And if we're supposed to be upgrading the Computer Misuse Act, my 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 interpretation would be that you would streamline the law, make sure it's better aligned with international treaties, especially when you're looking or you have expressed an intention to accede to the convention, or when the United Nations has finished the discussions on their cybercrime law, which aligns very much with the convention, then you're going to end up not misaligned with international and treaty and international law. So why not just at this point, when you have the opportunity, just remove a section that's not aligned with international law that serves no purpose, is already addressed by several other sections.